Hello everyone. Today I'd like to go over some details about the St. Kitts&Nevis Citizenship by Investment Program. I already mentioned this in my previous video where I talked about my experience with the program, but I thought it'd be worth pointing out a few things that apply to all applicants, not just those from Ukraine, Russia, and Belarus. So if you're considering a program like this, I highly recommend watching this before you make any decisions. Believe me, YouTube bloggers and other promoters of this program are never going to lay this out for you. Let's start with something called the C forms. These are the documents you need to fill out to apply for citizenship through the program. And the thing is, you've got to sign a contract with an authorized agent or an international marketing agent and pay up front before you even get to see the actual documents. And they are not free. I paid $750 for them. So in other words, you got to commit to the process first, and only then you can see through the paperwork and what you're actually agreeing to. So the form I really want to highlight today is the C4 form, section D, which is labeled as escrow agreement. Now, if you know what escrow means, you might be thinking, that's a good idea. They've added this for safety, so both parties are protected, right? Wrong, not really. Believe it or not, it's basically just the title of this section, and that's about it. There is hardly a word that actually spells out how the escrow is supposed to work. You can see for yourself on the screen. Now imagine some YouTubers recommending people to give up their top-tier passwords for paperwork this sloppy, careless, or maybe even shady. Just think about what that says about the government behind it. And here's why this matters so much. Basically, it means they can take and use your money before you are ever naturalized or get your passport. And that's not just theory. That's exactly what happened with the applicants from Ukraine, Russia, and Belarus starting in 2022. The government of St. Kitts&Nevis let the investors transfer the money, already knowing it would no longer process the applications, but at the same time giving no warning whatsoever that the process would be suspended. And since there was no proper escrow agreement in place, they most likely spend the money right away, right? To this day, the government still hasn't been able to properly refund all the applicants. They keep trying to stall for time and cover this up with excuses, saying the refund process all of a sudden is too complex and complicated, and they need to perform individual checks and assessments. But the reality is, they're still nowhere close to returning the money to all the investors. And honestly, the only reason they even respond or put out statements is because of the pressure coming from the people demanding their money back, and not because they feel any guilt about owing investors for so long. Taking the money was no problem, but when it comes to paying it back, suddenly it's a whole bunch of problems, right? Okay, now let's get back to the C form. What's this section D really about? It's about giving up your right to take the government of St. Kitts&Nevis to any public court, anywhere in the world. Instead, it says that all disputes have to be handled through private arbitration under the rules of the International Chamber of Commerce, ICC, with the proceedings seated in St. Kitts. What does that mean? Well, that means that you can't sue them in your local court back home. You can't take them to court in St. Kitts either. And everything has to go through a private process run by an arbitrator, not by a judge, with no option to appeal in a regular court. In other words, you lock yourself into private arbitration with no appeal, no public oversight, and often very limited procedural protections. Also, arbitration is typically confidential and tends to favor repeat players like governments and institutions. Now, they even specifically mentioned US courts in a separate paragraph, making it crystal clear that under no circumstances you can bring a case against them in the United States. Well, you gotta ask yourself, why would they set things up so you can't take them to court and only allow disputes to be resolved quietly through private arbitration? Let me know your thoughts in the comments. I'd really appreciate your input on this. Now, let's say you decide to move forward. You've paid an agent like $20,000 in due diligence and agent fees to get things rolling. You've gathered all the required documents, which takes a lot of time and effort. Then, this sketchy document appears before you, and they expect you to sign it without a second thought. What are you going to do if you don't feel comfortable signing it? Cancel everything? I bet no agent is going to give you a refund just because you changed your mind after reading the agreement, right? So, don't make the same mistake I did. Don't turn a blind eye to stuff like this. It's not that I didn't read this section before signing the C form. I did, and I didn't like it at all. But right before I transferred the contribution, I was under heavy pressure because of certain personal circumstances at the time. And I felt like I didn't have another option. In the end, it didn't work out, and it turned into a complete disaster. Anyway, I'd recommend you to bring this up with the bloggers who promote this program or any agents you are thinking of hiring. And let me know their responses in the comments. I'd love to see how they try to explain it away. That's it for now. Take care, and please read every document carefully and think twice, or maybe even 10 times before signing anything questionable. See you next time. Bye.